Hey everyone, welcome back to the channel. Today, we've got two wild courtroom moments to break down. We're kicking things off in Texas, where a classic Karen managed to land a surprisingly generous plea deal from the prosecution. The only issue? The judge can't seem to get past the fact that her criminal record is nearly 4 pages long. And to make things even more dramatic, she's struggling to keep quiet long enough to avoid getting herself arrested right there in the courtroom. Before we dive in, a quick thank you to today's sponsor, Chapter. A lot of people on Medicare end up spending hundreds or even thousands of extra dollars every year simply because they're placed into the wrong plan. And it's hard to blame them. Many get pushed into plans that benefit the broker, not the patient. That's where Chapter comes in. They launched their company after their own families got caught up in those kinds of situations, and they decided to fix it. When you call Chapter, you'll talk to an actual human being who will review every plan available in your area and help you find the one that truly fits your needs. And the best part is that the call costs you nothing. With the holidays approaching and the average senior saving over $1,000 a year by switching to a plan that actually works for them. Now is a perfect time to make sure you're not overpaying. Just call the number on your screen or visit the link in the description. Let a real expert review your options and see if you can save money, or confirm that you're already on the ideal plan. Thanks again to Chapter for sponsoring this video.
Mr. Lewis, you have Crystal Vogan, it's the sentencing. Good morning. This is Mr. Hoffpower's sentencing. I didn't see you over there, Mr. Hoffpower.
No, I did.
Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes. Yeah.
And any additions or corrections or?
There's a lot of history we understand, Your Honor, but discussed it with counsel also restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
Right. So do they know about this case? And what has happened over there, if anything?
I haven't done nothing. I'm still continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes,
school
ma'am.
with this type of
Yes,
criminal
ma'am.
history?
Deferred, yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
This is pretty much the last thing anyone wants to hear from a judge while they're reviewing a plea agreement. Even though a judge is supposed to remain neutral, they still hold the final authority to decide whether a plea deal actually serves the interest of justice. And in this situation, the judge isn't hesitating because she's unsure about whether this defendant should receive probation at all. What's really giving her pause is the type of probation the prosecution agreed to specifically. Deferred adjudication instead of traditional probation. For anyone unfamiliar, deferred adjudication is essentially a second chance with a legal safety net. If the defendant completes every requirement of probation without incident, they can return later and ask the court to have the conviction completely wiped from their record. It's an option usually reserved for people with minimal or no criminal history, people who made a mistake and are unlikely to repeat it. But this defendant isn't walking into court with a clean slate. She's walking in with nearly 4 pages of prior incidents trailing behind her, and the judge can't ignore that. So from the judge's perspective, allowing someone with such a lengthy history to walk away without a permanent mark on their record just doesn't sit right. It's not that she objects to probation entirely. She just isn't convinced that erasing the conviction is an appropriate option for someone who has had more than enough chances already.
Issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the recording.
Okay. So possibly the other person that was involved did that?
Only thing we knew about
That was
was $9,400 that was within the bank.
I wasn't aware, Your Honor, when we did it, when I got the PSIs, when I was notified, I was in the cash app. But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, $94 from inside the bank, $500 from an ATM, and $100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of
I
the,
don't have the other status of another person, Your Honor, that's just one that's the charge. I'm not coaching on there. But she's responsible.
yeah. So I mean, if there was another person, and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank, she didn't want to call it. Size, whether or not she has a conflict. The backside, not to my knowledge.
And hold on. So the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County? Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we understand.
So, all right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly.
You know, if someone were willing to overlook a handful of drug-related offenses, a scattering of financial schemes, and just 5 separate convictions involving the unlawful transport of individuals, then sure, she might almost pass for a model citizen on paper. But that's a pretty big if, and the judge isn't exactly the type to squint hard enough to make those pages vanish. And now comes the part that happens far too often in these courtroom sagas. Rather than taking the rare leniency being offered and quietly moving forward, She's about to make her own situation dramatically worse. It's like watching someone approach a do not touch sign and immediately poke it just to see what happens. The judge is already uneasy about the plea deal. The prosecution has already extended more generosity than her record deserves. And all she has to do is stay calm and follow the script. But staying quiet and cooperative is apparently the one thing she absolutely cannot do. And she's about to turn a manageable problem into a full-blown disaster entirely by her own doing.
I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do?
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 hearings and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases.
Yeah. I know judges using double negatives can tie your brain in knots too. But trust me, that linguistic hiccup is nothing compared to the frustration she's feeling on the bench. And with that, the hearing comes to a close. Now the real question becomes, will her employer keep her spot warm? While she tries to scrape together the $25,000 she now needs for bail. Something tells me I might be a little late this week. I'm dealing with a legal situation. Text message isn't going to cut it. Anyway. With that courtroom fire fully extinguished at least for the moment, it's time to head down to Florida, where the legal climate is always humid, chaotic, and just entertaining enough to keep me coming back. We've got several hearings to work through in a case I've been following for quite some time, and each one seems to find a new, creative way to go off the rails. So buckle up, because Florida courtrooms rarely disappoint.
Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all.
Just one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. Ma'am,
What?
this is not going to help.
It don't matter. My life's going on.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back.
I heard bullshit.
Everybody heard it.
He said you're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say that.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your criminal,
I gotta go to work, so I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
Who's on me like that? You know, I can look in the hood. Like this. I'm not doing that.
Did you not hear what he just said? The judge isn't being difficult, evasive, or mysterious. He's literally telling you the boundaries of his job. He cannot give you his opinion. He cannot help you out. He cannot secretly coach you through your next move. He is just as legally prohibited from giving you legal advice as he is from giving the prosecution legal advice. The courtroom isn't a group project. And the judge isn't your study buddy who can whisper the answers when you get stuck. This is one of those moments where the legal system expects you to understand the rules before you try to play the game. You chose to walk in without an attorney, which means the judge is forced to watch you stumble through a maze he's not allowed to map out for you. It's like asking the referee in a football game which plays you should run. He can't tell you, even if he can see you're about to fumble your entire future. But sure, go ahead and ask him again. I'm sure the third time will magically make him forget the entire judicial ethics code he's sworn to uphold.
Call Mr. McCoy's case.
Mr. McCoy?
Our conversations are included.
Mr. McCoy is here today. I've revoked his release based on his new charge. He held without bond on that. What else do we have? And Mr. McCoy, you understand that you're representing yourself. I have found you competent to represent yourself. At any point in time in these proceedings, you can ask an attorney if he appointed to represent you.
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Okay. All right. Looks like there's been some, there's been a DCA case filed. I don't know if it's based on the discovery request or not. I don't know. All right. Yes, that's what it looks like. All right. Anything else today?
No, Your Honor.
All right. Yes, sir.
Yes, sir. Well, first, I would just like to request to have my bond reinstated, sir.
Motion denied.
And reason being, sir, can I please have an explanation why?
If you were out on bond, you picked up another charge, you pled to that charge.
And the only reason, sir, regardless of the facts, the only reason I accepted the case, that charge is because they said they was only going to give me a fine. But the person that actually, was in the fight, they came there and they seen that I was breaking up the fight.
Mr. McCoy, I've already made my decision. When you entered,
I understand that, Mr. Clark. I'm just stating this for the record.
You've set the motion that you were breaking up a fight and that you didn't cause a fight and you weren't involved in the fight, that you were the peacemaker. But however, you did enter a plea, and that's all part of the record. I understand that, but I am going to deny your motion to reinstate the bond.
All right, Mr. Clark. Can we discuss my case? I was here for a court date on my case.
Well, you've already filed a notice of appeal on the second request for discovery, so I don't know what else there is to discuss today.
Well, and that I was wanting to discuss, sir, is the fact that, my subpoenas and everything never got responded to. I filed subpoenas through the court and to the people about my the videos of my evidence, sir.
Well, if they've been served with subpoenas and they haven't responded, you need to do a motion for show cause.
Motion to show cause.
Yes, sir.
Okay. What about, I just want to know your opinion, sir, since you're the judge.
I can't give you my opinion.
No. Based on the proceedings, sir.
So that's the end of his first hearing. And honestly, it went about as well as you'd expect for someone who treats bond conditions like optional side quests. The judge didn't just mention his slip-up, he reprimanded him outright. Because while he was out on bond for his original case, he somehow decided the best use of his freedom was to go pick up a brand new charge, and then plead guilty to it. Think about how wild that is. He was already on thin ice, already being monitored, already told explicitly, do not get into any more trouble, and he still managed to walk himself straight into another courtroom and say, yes, Your Honor, I did that too. When you're out on bond, you're basically being handed a loan of trust from the court. The bare minimum requirement is, don't commit more crimes. Not don't get caught, not don't do anything too crazy, just don't commit more crimes. And he couldn't even clear that embarrassingly low bar. So, now the judge, who is already skeptical, gets confirmation that this defendant can't be trusted for the length of a loading screen. And that's going to hang over him for the rest of the case like a storm cloud with a grudge.
That's what Mr. Frank Sullivan. It's not looking for help. All the thing I'm asking, sir, is why am I being denied my evidence?
I don't know, sir.
Okay, if Bay County officers was the primary officer, sir, in my case,
Okay.
and they will only be assisted
I've heard this argument for the last, ever since you've been arrested, so it's already part of the record. I've already made my ruling. You've already appealed that ruling, so we'll see what the first DCA says. I'm gonna set this for a pretrial June 19th at 9 o'clock. That'll conclude the hearing. Okay?
Well, sir, I still had a couple things I really wanted to say for the record.
Say them on the 19th.
Seriously, come on, Ms. Clark, man, we got.
What do you want to put on the record? I'm gonna give you a minute. Go.
All right. The whole thing I want to put on the record, Ms. Clark, is I don't know what kind of beef that you got with me, sir, or Mr. Frank Sullivan, but I keep having multiple prosecutors filing motions against me, the ones that was pulled off of my case. Why they still filing motions
Mr.
against me?
McCoy, I understand that argument.
But it makes no sense because it seems like my case is going nowhere,
Listen,
especially when you have nothing to even
These
try
state
to.
attorneys don't stay here very long. The ones that are on your case are in another division. I have nothing to do with that. Mr. Sullivan has nothing to do with that.
You know, he just said he does.
Huh?
He just said he did, though.
No, what I said, Mr. McCoy said that despite who the prosecutor is, you're also involved in my case. And I said, yes, that is true because I'm the division chief. I didn't say it had anything to do with moving prosecutors or changing.
He doesn't move, but he is the division chief, so.
Okay, if
Request.
my old prosecutors already moved to a different division, whatever, why is she still filing motions against me? And then obviously when she signed it, she said this motion is for Frank Sullivan.
They all sign it for Larry Bassford. It doesn't matter who signs it, who files it. They're filed on behalf of Larry Bassford. So that's going to conclude today's hearing.
That makes no sense, Mr. Clark.
Mr. McCoy, that concludes the hearing. I understand. There's nothing else to be said about that.
I never get tired of watching people convince themselves that a handful of daytime court shows has magically granted them a law degree. Something about watching 3 episodes of Judge Judy makes them think. They've absorbed the entire criminal code through osmosis and are now fully qualified to stand up in a real courtroom and out-argue trained attorneys. Spoiler alert, they're not. And in criminal matters, representing yourself almost never ends in anything other than embarrassment, frustration, and a rapid decline in whatever patience the judge had left. It's almost like watching someone try to perform surgery. Because they once saw a medical drama, they have just enough surface-level confidence to be dangerous and absolutely none of the skill needed to survive the experience. The courtroom isn't a place where winging it is a strategy. But some people insist on learning that the hard way. So, with that predictable disaster already unfolding, let's move on to his next hearing and watch him dig this hole just a little deeper.
This is Devontae McCoy, case number 24 CF 2543 and 24 CF 2544. Mr. McCoy has made the decision to represent himself. Mr. McCoy, do you wish to continue to represent yourself?
Yes, sir.
We're set for a pretrial today. Where are we at?
I filed a few motions, Your Honor.
I've denied the motion to set bail. I've denied the motion to quash order to revoke bond.
Okay, Your Honor, can the state at least, or can somebody at least explain to me why I deserve to be held without bond?
No, sir. I've already done that, and I've already made the decision. You're being held without bond because you were arrested on a new charge, and you pled to that charge,
And I've already discussed that, so we're not gonna have any more discussion on that.
Well, Your Honor, I would like to state for the record, due to the fact that, you know, it's on record and also by the person that actually committed that crime that day.
I've already heard that argument that you were
Mr.
making.
Clark.
Listen to me. I've heard the argument that you were a peacemaker, but you pled to that charge. We're not hearing anything else about setting a bond or anything else.
I never pled
What else
guilty
do we
to
need
the
to address
charge,
today?
Well, I put in a motion to dismiss the information due to double jeopardy clause. So
All right, that will be denied, but I'll get you a written order.
Well,
Or anything
can I, wait a minute, Your Honor, I need to state something for the record. I mean, I'm trying to understand why is my motion being denied without being heard.
I'm gonna
Not
get you a
hearing
written
my
order.
motion, Your Honor.
Anything else besides?
Yes, I'm trying to get my motion heard. I want my motion to be heard, Your Honor. I want to speak.
I'm gonna review it first, because I'm gonna get you an order. I'm gonna get you an order, and if you want to do a motion for rehearing, you can do that. What else we need to do today?
I want my motion heard, Your Honor. I want to speak.
What else we need to do today?
I'm going to speak on my motion, Your Honor.
All right, let's go ahead and set it for trial. We're gonna set it for trial October the,
You setting for trial? I'm trying to discuss something with the state, Mr. Clark.
you have time to negotiate between now and then, October 6th, and we'll set it for a trial management, August 21st at 9 o'clock.
Wait a minute, also, what
Thank you, Your Honor.
about, that's not my last motion. That's not my last
Mr.
motion.
McCoy, that's all we're gonna take up today.
What about my motion for, by my evidence, Your Honor?
I've already, denied that.
Motion to preserve evidence? How can you deny a motion to preserve evidence?
I'll look at that. I haven't seen that yet. It's filed, but I have not seen it. That'll conclude today's hearing, Mr. McCoy. We'll see you.
I filed that a month ago.
Yes, sir. Mr. McCoy, it wasn't sent to me, so that'll conclude the hearing.
So you sending me for trial?
That will conclude the hearing.
Wait a minute.
Y'all take him out.
Listen, man, it's crazy.
Take him out. Go ahead and y'all get him.
I'm gonna ask you to disqualify yourself from my case.
All right, well, take a written, we'll take it up the written. Mr. McCoy, go ahead and take him out, Brian.
It is not the prosecutor's responsibility to track down evidence that could help your defense. Their job is to represent the state, not to babysit a defendant who decided that Google and overconfidence were an acceptable substitute for legal counsel. That means if you want exculpatory evidence, you or an actual attorney have to go out and get it yourselves. But wait a second. You can't, can you? Because you made the brilliant decision to represent yourself while simultaneously being held in jail. So now, instead of having someone on the outside gathering documents, reviewing footage, or pulling records that might help you, you're stuck trying to build a defense from behind. Bars with nothing but a few outdated law books and your own questionable judgment. It's almost impressive in a tragic sort of way. Choosing the path that gives you the fewest tools, the least flexibility, and the highest chance of failure, all while insisting that you've got everything under control. This is why courts almost always recommend you get a lawyer, not because they doubt your intelligence, but because reality tends to do that for them, and with that self-inflicted setback hanging over everything. Let's continue on and see just how much deeper this situation can.
Say, is that correct?
Yes, sir.
Okay. See, I know you've got some stuff filed at First DCA, and also you have something transferred by me to federal court. You got that order?
Federal court.
Yeah, it was a pro se petition for writ of habeas corpus under 28 USC. That was transferred to federal court to allow you to litigate that.
Suppose he's expecting the prosecution to magically invent evidence out of thin air evidence that not only doesn't exist, but would somehow prove his innocence. It's almost as if he believes the state has a secret file labeled helpful information for the defendant that they're just refusing to hand over. But reality doesn't work.
Yeah. Well, if this is state of Florida versus Devontae McCoy, 24 CF 2543, 24 CF 2544. Mr. McCoy is before the court pro se. Mr. McCoy, you understand at any point in time, you can ask an attorney to be appointed to represent you, and one will be appointed to represent you, no charge. You understand?
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
We're set for a trial management today, is that correct?
Yes.
All right. Mr. McCoy?
I was coming to address a couple of motions that I have filed, which was Richardson here, based on the evidence that was destroyed that I was, requesting over this year period.
Okay, what evidence is that?
Same one that we've had this hearing 5 times on, Judge. The video from the Sefco gas station that doesn't exist.
And the body cam from the FHP and the body cam from the Bay County SID.
The dash cam from FHP has been provided to Mr. McCoy. I handed him the discs in court personally.
So that's not the initial. I need the body cam from the Bay County SID because the FHP was only assistant Bay County.
Judge, sorry, you can finish.
You can go if you got something to say.
Judge, we've had this hearing 5 times already.
Okay, I understand that. I'm just addressing that, Mr. Frank Sullivan, because without this evidence, that's prejudiced me in preparing for my trial.
Okay, what evidence don't you have?
It's the exculpatory evidence. The video request, I filed like 7 motions.
What video?
The video from the Sefco gas station.
Okay, that I've already ruled on that.
Well, and why is that? That's exculpatory evidence. I need that in order to defend